where should we draw the line? I think a good place to start is international law, international refugee law, which the UK has signed up to, the US has signed up to. It's illegal to force people who are fleeing a well-founded fear of persecution. It's illegal not to take them, not to accept them, and certainly illegal to push them back into harm's way. And leave alone the fact that it's also illegal to just murder civilians, which is what you'd be doing if you were shooting at migrants. So a good place to start is just going back to international refugee law, which has been in place for now 70 years, and make sure that those basic protections are respected. Because if you don't use law as a barometer, as a basic benchmark for how people on the move should be treated, then you're in danger of eroding their rights, and you pick and choose on a basis of a political situation in a particular country. But so, international refugee law is not perfect, but there have been lots of questions when the 1951 Refugee Convention turned 50. There was questions about whether we should renegotiate it, and then when it turned 70, should we renegotiate it? The answer is absolutely no, because if in this current political climate, if you were to renegotiate international refugee law, you'd come up with something a lot less effective, less protective, basically, right?
Sorry, are you saying we shouldn't renegotiate it because of the current political climate we're in?
Because as imperfect as refugee law is now, it would be much more imperfect if we were to allow today's politicians to negotiate a new settlement, right?
The climate around it has changed. What did they agree on in 1951?
So they agreed that everyone has the right to seek protection. They defined what the bases of what they call a well-founded fear of persecution, that on the basis of race, nationality, political opinion, membership of a social group, etc. That gives you a really broad range of categories and of grounds upon which to recognize someone who has a fear for their life. It doesn't cover questions about climate migration. It doesn't cover questions about there's a whole range of things it doesn't cover, but it does cover a lot. And I think if you were to renegotiate it now, you'd get something much less, much more restrictive, much less protective, if you like. So that's where I would say to go back to. Just to go back to your example, though, of Yemen and Saudi Arabia, these kinds of killings of people on the border has happened multiple times. It doesn't stop people from moving, though. They're still coming. They're still going at it. They know what some of the risks are. But again, they say some people, really unlucky people, get targeted by those attacks, but many more people find their way around. So, I've just been working with a team of people doing some research with Ethiopians who have gone to Yemen and Saudi Arabia and the Gulf countries and come back to Ethiopia. Some of them have gone 2-3 times. And even though it's difficult to get there, it's difficult to get into the country, they're not well treated in their workplace, sometimes they get deported, they go back again because they also feel that they have a responsibility to their families to send money home, and that's the only future their families have is that small money that they're able to send back. There's a sense of shame if they are deported and they come back empty-handed. So there's all this quite complicated stuff, but even that doesn't stop people.
I think it's quite interesting how you said we definitely need to reconstruct international law, but because of the political climate we're in, this shouldn't be done. But the anti-migration rhetoric has only grown with years.
Yeah.
And I don't see how we'll be in a situation where where we've actually gone, where the anti-migration rhetoric has gone the other way, or it subsides.
Been more generous somehow.
Yeah. So are we just stuck with this law, which is substandard? Do you think there's no way to improve this?
Well, I think that the reason that refugee law is as expansive as it is because of when it was created. So it was created right at the end of World War II, right? When there was a feeling, it was originally international refugee law was intended to apply only to people who were on the move in Europe as a result of the events of World War II. And so there was a real feeling of responsibility that we need to take care of these people. And then only gradually through decolonization of Africa and parts of Asia, and the recognition that the problems that Europeans were facing were also being faced by people in other continents, that that later on the restriction on where people are living who are fleeing persecution was lifted, and now it applies across the world. Again, that came at a time of really kind of expansionist, more internationalist thinking than we currently have now. So the opportunity for renegotiating is not going to come until there's another big expansionist moment, whatever that may be, right? Right now, where countries are pulling their borders up and thinking about us first. It's always about me first. It's not a good climate for renegotiation. But that's not to say that you can't do anything. So I think that there are lots of opportunities. The way that international refugee law is written is it's quite it's not vague, but it provides a lot of space for national courts and for precedent to be set. So, for instance, a good example is that in Latin America, some asylum seekers were coming into the U.S. claiming that they were fleeing from a social group, which is a protected category under international refugee law. The social group that they said they were fleeing was gangs, which at first courts were like, "What are you talking about, gangs? You have to be not only a member of the social group, but you have to be persecuted at the hands of the state. So it's not because your neighbor is trying to kill you that you can get asylum. It's because the state is trying to kill you, or the state is not willing or able to help you when someone else is trying to kill you." And that was the thing that the would-be gang members were saying is, I had to flee the country because I didn't want to be part of a gang. And the government of Honduras, say, was not able or willing to prevent the gangs from coming after me. So there was a state role in my own persecution. So actually that started to be accepted. And now in many courts and many immigration councils in the U.S. will accept membership of a gang or would-be membership of a gang as a reason to be accepted as a refugee. So I give that example as a way in which the existing definition has slowly been expanded to adapt to the current changing situation on the ground today, to give people more protection. So without changing the law, you change the interpretation. And once you have a few people whose asylum claims are recognized on the basis of persecution from a gang, then the more it sets the standard that people know or that lawyers know that there's a pathway to helping those kinds of people. So there are ways of flexing international refugee law to adapt to some of the changing circumstances here, even without changing the law itself. And that's what good refugee lawyers try to do, is try to always kind of push the boundaries a little bit of what is meant, or try to show how the current situation does rise to the level of what this law says. And which is the same thing you do with constitutional law. I mean, the constitutions of most countries were written in a very different historical period, but we constantly apply them to the current modern day and say, what does that mean in today's world? So the same kind of thing is happening.